So getting organized involves certainly knowing what you need to organize. How many of us have done a data collection from our clients? Show of hands. All right. And how many of us have collected, for example, email? Documents like Word files, spreadsheets, voicemail data, logs from the parking garage. Right. So what are the sources of ESI, right? So there's email, instant messaging. People collect personal computers sometimes to do forensic images of them, see what was deleted. There's enterprise systems, human resources, inventory systems, accounting systems, telecom data, devices, right? Bring your own device now. We have smartphones and all manner of devices, soon to be smartwatches and smart glasses, right? Are all coming in. Cloud storage, social media, logs, and so much more. But what's relevant to your case, right? And I think Drew makes a great point, right? In getting organized, you have to figure out, what's my case about? This is a trade secret case. Okay. That means the allegation is that the employee left and copied the data from the old employer. A forensic copy of his old computer might be really important. This is a case about where someone was at 7 p.m. on a particular night. Wow, the logs of that parking garage over there. Every time it opens and closes, I use a badge to get in. There's a record being made of that. When I get to work and I sign in on my computer, there's not only a local record on my computer, and yours when you sign in, but your company probably has a record of when you log in and when you log out and when you launch programs and which programs you launched and what time you launched the program and which files you downloaded. Oh, you didn't know this, sorry. I mean, they do, and all this information is available. And we all, throw around this word spoliation when it's gone, right? But before you figure out what you've got to get organized with, you got to figure out what's relevant to your case. So you look at this list again and you go, wow. What could be relevant to my case? What kind of things am I trying to prove, and why? And that's really where you have to start. So you need context now from the rules. What do the rules require me to think about? Well, the first thing is you've got Rule 26b1. And that says that we're allowed to discover things that are relevant to the claims and defenses, right? And I've got 26g, which how many of us have signed a discovery request? Can anybody tell me what 26G says? I'll tell you. I didn't really mean for anyone to put anyone on the spot here. 26G says that I, by signing this discovery request, certify to the court that this is not unduly burdensome. Pretty cool motion, right? Dear Judge, I move to sanction them for serving unduly burdensome discovery. I mean, I haven't seen much of that litigation, but you are making that certification, and you could go after someone for signing a discovery request that would be unduly burdensome. 26b2b, very important rule about the scope of ESI discovery, because it limits your need to search through things that a party identifies as not reasonably accessible. Probably the most misunderstood safe harbor I've ever seen. But what it means to identify something as not reasonably accessible, it doesn't mean that you looked at it and said, wow, that's going to be hard to get to. It means you told your adversary enough to make a motion to compel. I'm not looking at those backup tapes because they're unduly burdensome. That's not enough. You've got to tell your adversary which tapes you're not looking at in order to get the protection of 26b2b. Then you got 26b2c on proportionality. And it says, well, you got to weigh the needs of the case. And that works, by the way, not just for ESI, but 26b2c applies to everything, right? And then Rule 37a4, you give an incomplete response, and it's treated as a failure to respond. So you have to think have I really responded fully in discovery? Have I said all documents? Has anybody looked yet at the proposed federal rules that are supposed to get enacted sooner or later? A few of us. Interestingly, there's going to be a heightened requirement to actually say which documents you're going to produce when you object. You can't just say, well, I object to this, and then produce what you do. You have to sort of tell them what you're going to do. We also have 26F, right? You have to discuss preserving discoverable information. at your 26F conference. And you have to address ESI disclosures. You have to address ESI discovery. You have to address the form of ESI. Now, I'm not going to bore you with a lot more rules, but I have a lot more. Because when you think about what's relevant, and that's where we started, you have federal rules of evidence, 401, 402, and Rule 105, so you can limit the purpose for which things might be introduced. But you also have to think about, and Drew mentioned it, right, is how am I going to get this stuff into evidence, right? How am I going to authenticate this evidence as I'm getting organized? You know, what am I going to do with this evidence? And I put a bunch and here's some interesting questions about e-discovery. So official publications are self-authenticating. Is anything that's ESI an official publication? Interesting question. I'm not sure I have the answer today, but it's a great topic. What about newspapers and periodicals? We all know they're self-authenticating. We learned that in law school. But is the front page of a website a newspaper or periodical, even if it belongs to the New York Times, for the purposes of self-authentication? What if someone copied it? What if someone PDF'd a website on a given date, now it's on their computer? Do you have a self-authenticating document? So as you're thinking about the scope of what you're trying to collect and what's relevant to your case, you should be thinking about some of these rules. Inadvertent disclosure, we all know that 502B now kind of allows us to take a quicker look through our documents and maybe not have to catch everything that's privileged along the way. But when does that disclosure become inadvertent? So again, as you're getting organized, you know, how am I going to screen for privilege? What about hearsay exceptions, all applying to ESI? Can an email be an excited utterance or come in under a state of mind exception? All things you have to think about as you're getting organized. What's the scope of this ESI? And I know we play with these rules a lot. What about FRE 1002, the requirement of an original, and 103, the admissibility of a duplicate? Do those concepts make any sense? Should you be challenging your opponent's evidence under FRE 1002 now? And the residual exception, which of course I use whenever there's not another good rule to bring in the stuff that I want, which is, hey, judge, there are some guarantees of trustworthiness. Right? There's some reason to bring this in, even though I can't find the right exception for it because they wrote these rules of evidence a long time ago. But all of this has to come into your calculus of what's important, what's relevant to your case, and how it's going to fit into that organization. How am I going to use this? Who will testify to it? Where does that chain of custody come from? So Drew made a perfect example. So you go and collect the computer from your client. By the way, I think it's a really bad idea. I try not to touch evidence. But we're collecting a cell phone. So I go ahead and I take possession of that cell phone. This one is turned on. It's mine. It's okay. It's not Drew's, I promise. And I take possession of it. And I bring it with me in my car. And I get somewhere else and I give it to my forensics examiner. Just a roll for the moment. Where's the chain of custody? What did I do with that cell phone? Do I have to now testify what happened? Why shouldn't I have my forensics examiner pick it up and image it straight from its source? Why did I get involved in that? I mean, when attorneys start getting involved in this, how did that cell phone change because of the time I had it and the fact that it was power on? Why didn't I ask Drew to turn it off and give it in that off state to the forensic examiner? Did new locations get added to its memory? Did things get deleted over time, right? I say, don't touch this evidence and let your forensics people do it. Work with a team.